Welcome to this explainer. Today, we're going on a really fascinating journey to demystify the legal frameworks that govern, well, almost every single action we take online. Whether you're buying a coffee with your phone, writing some code, or just scrolling through your feed, there's this massive, invisible legal architecture working behind the scenes.
People constantly ask me, is cyberspace just some lawless frontier? And I can tell you right now, the answer, instantly and emphatically, is no. Sure, it might feel like the Wild West sometimes, but traditional legal concepts haven't just disappeared. They've actually adapted brilliantly to govern and protect this vast digital space.
Okay, let's dive right into this. To see how our rights still apply online, we're going to explore the digital life cycle, owning your digital ideas, validating digital transactions, cybercrimes in the law, and finally, resolving digital disputes.
All right, starting with Section 1, owning your digital ideas, intellectual property in the digital age.
So, when you create something online, the law actually has your back. Intellectual property is this brilliant system that balances your private reward with the public's benefit. Think of it like this. If you invent a brand new technological product or process, patent law steps in and gives you 20 years of exclusive rights. Now, if you build a brand identity, like a catchy slogan or a logo, trademark law protects that for 10 years and you can keep renewing it so consumers don't get confused. And if you create an original expression, like art, music, or a literary work, that's where copyright law comes into play.
And I really want to emphasize this number right here, 60. Under the Copyright Act, your original creations are protected for your entire lifetime, plus an additional 60 years. That is literally an immense lifespan of protection. And the best part? This protection kicks in automatically the very second you create the work.
But here's where it gets kind of tricky, and it's a question that always sparks a ton of curiosity. Where exactly does computer code fit into this whole legal matrix? Is a piece of software covered by a copyright, or is it a patent?
Well, the answer is actually both, depending entirely on what it does. Pure computer software, just in its coded form, is primarily protected as a literary work under copyright, just like a book. Pure algorithms or abstract business methods, those simply cannot be patented. However, if your software demonstrates a technical innovation that's actively embedded within a hardware-based invention and it produces a measurable industrial effect, then it actually can be granted patent protection. It's all about the application.
Now, as we build up all these digital assets, we obviously need a digital address, right? Our domain names. They function as our digital business identifiers. But what happens when someone registers a domain name that looks super similar to a well-known brand just to piggyback off the reputation and make a quick buck? That right there is called cybersquatting. Courts recognize that domain names are incredibly valuable intellectual property, so these disputes are tied directly to trademark infringement and passing off principles.
And hey, it's not just software and websites we're talking about, it's our data too. Building an electronic database takes a huge financial and intellectual investment. They get copyright protection if the way the data is selected or arranged is actually original. Think about, say, a hospital's digital patient record system. That database stores highly sensitive medical histories. Someone making an unauthorized copy of that database isn't just a technical glitch, it's a direct violation of intellectual property rights, confidentiality clauses, and licensing agreements that were put there specifically to limit access.
Moving on to Section 2, validating digital transactions, making e-commerce legally binding.
So if you want the business we do online to actually hold up in court, we have to look at how agreements have evolved. Traditionally, we relied on face-to-face negotiations, written paper documents, and physical pen and ink signatures. Today, we're dealing with electronic contracts, emails, online forms, and those click-wrap agreements we all scroll past. But here is the absolute secret. Despite radically different mediums, both forms require the exact same traditional legal elements. You still absolutely need a clear offer, acceptance, lawful consideration, and the intention to create legal relations. The core law hasn't changed at all, just the execution.
Which begs the question, how do you sign something you can't even touch? You use digital signatures. These are cryptographic techniques that securely link a signer's identity directly to a document. And this is crucial because it prevents them from later denying they ever signed it, a concept in law known as repudiation. Under the Information Technology Act, as long as it's issued through an authorized certifying authority, clicking I agree or using one of these digital signatures carries the exact same legal weight as your handwritten signature. No difference whatsoever.
Naturally, a lot of these contracts involve money. That's where the Reserve Bank Act comes in. It provides this massive regulatory framework that keeps our digital banking and payment systems secure.
It empowers authorities to mandate secure digital payments, strict authentication mechanisms, and heavy fraud monitoring. Basically, it's an entire infrastructure designed to safeguard against systemic risks and keep the national monetary system stable while you're casually tapping your card or transferring funds on your phone.
All right, Section 3, Cybercrimes and the Law, when the virtual world causes real harm.
Because let's be real, the virtual world absolutely can and does cause very real harm. That's why the Indian Penal Code applies traditional criminal laws, things like cheating, identity theft, fraud, and forgery, directly to cyberspace. But how do you actually prove it in court? Well, it's a three-step process. First, the IT Act intersects seamlessly with civil and criminal procedure codes, which gives investigators the framework to collect digital evidence like server logs and emails. Second, those electronic records have to be properly certified regarding how they were produced to prove they're authentic. And finally, they are admitted into judicial proceedings. This even covers digital banking logs under the banker's book's evidence framework, meaning banks don't have to haul giant physical paper ledgers into court anymore.
The law also takes the deep, personal impact of these digital crimes incredibly seriously. Take cyberstalking, for example, repeated online harassment, threats, or unwanted surveillance. The consequences for the victim are profound. We're talking severe emotional distress, fear for personal safety, reputational damage, deep psychological trauma, and social isolation. This is exactly why cyberstalking carries such strict criminal penalties. And it's actually worth noting here that employers also carry a strict legal responsibility to regulate their employees' internet use and enforce acceptable usage policies just to prevent this kind of digital misuse and reputational harm from happening on their watch.
Another incredibly complex area we have to talk about is cyberpornography. Distributing explicit material through digital platforms brings up massive societal impacts. There are moral concerns, severe exploitation risks, and real psychological harm, especially when it comes to the exposure of minors. Legal frameworks have this seriously difficult task of navigating all this. They aim to restrict obscene or exploitative content, but they are constantly trying to balance the protection of human dignity and public morality against the fundamental principles of freedom of expression. It is a very fine line to walk. Which brings us to Section 4, Resolving Digital Disputes, Justice in Cyberspace. So what actually happens when online transactions fail or your rights are violated? Traditional courts can be incredibly slow, which, isn't great for the ultra-fast-paced tech world. Enter ADR, or Alternative Dispute Resolution. This is basically the practice of settling disputes completely outside of traditional courts through negotiation, mediation, or arbitration. It is significantly faster, way less expensive, and highly flexible. Plus, there are two massive benefits here for cyber law. ADR is strictly confidential, which protects valuable trade secrets and business data, and it allows you to bring in highly specialized technical experts to resolve super complex software or data management disputes.
Now, take that ADR concept, put it on the internet, and you get online dispute resolution, or ODR. Everything from the initial complaints to the hearings to evidence submission happens entirely virtually. It handles a massive range of issues: e-commerce conflicts like defective products or refund fights, domain name disputes, IP conflicts, cross-border agreements, and data misuse. The crucial point here is this: because it operates 100% virtually, ODR is incredibly effective when the conflicting parties, like a buyer and a seller, are located in completely different legal jurisdictions or even different countries altogether.
And for enforcing specific cyber legislation, we have specialized bodies like the Cyber Regulations Appellate Tribunal. This tribunal was set up specifically to hear appeals against orders passed by adjudicating officers under cyber law. It is just a prime example of having a technically informed body in place to ensure faster decisions, provide efficient remedies against administrative penalties, and ultimately really strengthen the enforcement of our cyber laws.
Which brings us to a fascinating close. We've seen today how beautifully traditional legal concepts, from basic contracts to criminal evidence to intellectual property, have adapted to govern the internet. And it leaves me with this one provocative thought for you. As our physical and digital lives merge completely, as every single transaction, communication, and creation relies entirely on the digital frontier, will cyber law eventually just drop the cyber? Will it eventually just become law? Thank you so much for joining me on this explainer. I really hope this helped you better navigate our digital world. Keep questioning, keep learning, and I'll see you next time.